Hello students, my name is Shibani Ghosh. I'm an environmental lawyer. I practice in courts specializing in environmental cases. I also do research and writing on various environmental law and regulation related issues, and I'm associated with a think tank in Delhi called the Center for Policy Research. I've also been associated with the Central Information Commission, which is the apex body under the Right to Information Act, and I'm involved in various research projects dealing with the right to information and environment. Now today the module that we are going to discuss is on the environmental clearance process under the EI notification of 2006. Now as you know, industrial activities and projects like power plants, mining, highways, setting up industries, construction, they all require different types of permissions, approvals, consents before commencing operations. And several of these consents or approvals are required under environmental laws. One such approval or consent is called the environmental clearance, which is given to projects after a rigorous assessment of the potential impacts of the project on the environment, as well as after undertaking a rigorous public consultation involving people who are interested in the project as well as communities who will be potentially affected by the project. Once that process is over, an environmental clearance may be granted by the concerned governmental agency, and this clearance has to be obtained by the project proponents before they commence any operations. Now, what do we hope to achieve through this module? First of all, I'll try and explain to you the rationale behind why an environmental clearance is required from various projects. Also, what is the real procedure through which project proponents can apply for the environment clearance, and what are the various stages in that process, which are the important institutions that are involved and the stakeholders and actors that are involved in the process. And then we'll finally move on to what is the grievance redressal mechanism that is relevant, and also what are the different concerns that have arisen over the last 8 years in the design and implementation of this notification of 2006. Now moving on to first, what is the rationale behind requiring projects to obtain an environmental clearance before they commence operations? The main reason, or the main the foundation principle for requiring environmental clearance is to ensure that the environment is protected from any adverse impacts which are likely to be an outcome of industrial or infrastructure development related activities. Now, what could these potential impacts be? For example, air pollution, water pollution such as groundwater contamination, depletion or degradation of habitats and forests, wetlands, grasslands get affected, impacts on existing livelihoods, destruction of flora and fauna species. These are the various impacts on the environment. Now, the environment clearance process is meant to ensure that these projects or these development activities are only permitted if their impact on the environment is minimal and adequate measures are taken to prevent any adverse impact on the environment, and if there is likely to be any adverse impact, to minimize the same. Now, this would require that before an environmental clearance is actually granted, that we need to understand what are the potential impacts of the proposed project, and for that a proper assessment has to be undertaken. Now, this assessment is based on scientific and technical studies which form together the Environmental Impact Assessment Study, or the EIA report. These reports, along with public consultation that is undertaken around the project site, involving people who are affected or interested by the project, is then considered by the relevant agencies to decide whether this project should be granted an environmental clearance or not. Now, let's step back a bit to see what is the relevant law which governs the environment clearance process. Now, the main law in this regard, which is relevant to us, is the Environment Protection Act of 1986. the Environment Protection Act empowers the central government to take all such measures for protecting and improving the quality of the environment and preventing, controlling and abating environmental pollution. Along with that, the central government also has the power to restrict areas or regulate areas in which any industry, operation or process or class of industries, operations or processes shall not be carried out or shall be carried out along with certain conditions. Now, this power of the central government to restrict the areas or to regulate the areas in which certain kind of projects can come up is really the basis for the environmental clearance process. And this has led to the notification that was issued in 2006, which is commonly referred to as the Environmental Impact Assessment or EIA notification of 2006. The first thing that the EIA notification of 2006 does is to categorize all projects based on their spatial extent and the potential impact of these projects on human health and natural and man-made resources into categories A and category B. Category A are projects which will require a clearance, an environmental clearance from the central government through the Ministry of Environment and Forest and Climate Change, and category B projects will obtain an environmental clearance from the State Environment Impact Assessment Authority or SEIAA, which is a state government appointed agency. Now, let's go back and discuss certain examples of what are category A and category B projects. If we look at coal-based thermal power plants which have a capacity of 500 megawatt or above are categorized as category A projects. Those below 500 megawatt capacity are categorized as category B projects. In case of mining projects, those which are undertaken in acreage of 50 hectares or more are categorized as category A, and those below 50 hectares are categorized as category B. Now, there are certain projects such as airports, shipbreaking units, oil and gas transportation pipelines, which are massive infrastructure related projects which are of national importance, which are always categorized as category A projects, and certain smaller projects such as solid waste management facilities or common municipal waste facilities, which are smaller projects which are always categorized as category B projects. And as I said, category A projects receive clearances from the central government and category B projects receive clearances from the state government. However, there are certain exceptions to this rule. In some cases, category B projects which are located for instance within 5-kilometer radius of a protected area such as a national park or a wildlife sanctuary, or they are in close proximity to a critically polluted area or an eco-sensitive area, or they are near an interstate boundary, these projects, even though they are category B projects, they are required to approach the central government for a clearance. So therefore, they are treated as category A projects for all practical purposes. Now, this EI notification 2006, as I said, gets its source from the Environment Protection Act. So, the EI notification 2006 has been issued by the central government, which is the nodal agency being the Ministry of Environment, Forest and Climate Change. As that is the nodal agency, it has the power to make amendments to this notification. It has the power to ensure the implementation, proper implementation of this notification. It can expand and restrict the scope of this notification as well. So, it can exclude certain projects from its implementation, or it can increase the kinds of projects which require environmental clearance. Now, what are the main institutions that are involved in the grant of the environmental clearance? At the central government level, as I mentioned earlier, these are the category A projects and certain category B projects. The main agency is the Ministry of Environment, Forest and Climate Change, or MOEFCC, which grants the environmental clearance and is also responsible for monitoring the conditions, or rather monitoring the compliance of conditions that are laid in the environmental clearance. The second set of institutions of the central government which are important for our purposes are what are referred to as the Expert Appraisal Committees, or EAC. EACs are specially constituted bodies involving experts in different areas. They only have a recommendatory role. They appraise different documents related to the project, including, as I mentioned, the EI reports or the public consultation, which we'll come to a little later in today's presentation, and they give their recommendations to the Ministry of Environment, Forest, Climate Change. At the central level, there are at least 8 such committees which look at different types of projects. So, for example, there is a different EAC for coal mining projects, there is a different EAC for hydropower projects, and there is a different EAC for nuclear power projects. For category B projects, as I mentioned earlier, the projects are granted clearance at the state level. The agency that is the final regulatory body, or the body which grants the final clearance, is the State Environment Impact Assessment Authority, or SEIAA, which is responsible for actually granting the clearance as well as for monitoring the compliance of conditions in the clearance. Very similar to the work that is done by the MOEF with regard to the category A projects. Similar to the expert appraisal committees that we just discussed, we have the state expert appraisal committees, SEACs, at the state government level to give recommendations to the SEIAA based on appraisal of different documents such as the EI report and the public consultation minutes of the hearing. The third set of institutions is the state pollution control boards. These are pollution control boards set up at every state. These are responsible for organizing public hearings, and which is an important part of the public consultation process. They are also assisted by the local administration, for instance, the district collector, the subdivisional magistrate, the Zilla Parishad. All these institutions at the local level are also involved in the environment clearance process to a certain extent, particularly at the public consultation stage. The final institution that is important for our purpose is the National Green Tribunal, which is a specialized court based in New Delhi, but with different branches across the country, which hears matters and decides matters with regard to the environmental clearance process. And we'll come to the role of the National Green Tribunal towards the end of our presentation today. Now, as I said in the beginning, the crux of this notification of 2006 is that the environmental clearance has to be obtained prior to the commencement of any operation. Any new project or expansion of an existing project or modernization of an existing project or capacity enhancement requires such an environmental clearance. In August 2010, the MOEF clearly stated that projects which have not received environmental clearance cannot undertake any form of activity, including civil construction or cutting down or felling of trees. Projects which have not got environmental clearance but do have access to the project land, the maximum they can do is fence the land and to prevent encroachment, and to construct a temporary guard shed if necessary. Other than that, no other activity is permitted at the project site unless an environmental clearance is obtained. To begin the process, the project proponent or the company owner submits a number of documents to the relevant regulatory agency. As I said before, for category A projects, that would be the Ministry of Environment and Forest, Climate Change at the central government, and if it is a category B project, these documents will be submitted to the SEIAA, or the State Environment Impact Assessment Authority. Now, what are these documents? Form 1 and Form 1A in case of construction projects. These two forms provide the basic information about the project, such as where is the project situated, what is the capacity of the project, what are the raw materials that will be required in the project, who are the people who will be affected, what kind of employment will be generated. So, basic information about the project. The project proponent will also, along with the Form 1 or Form 1A, submit what are known as the draft terms of reference. Draft terms of reference or TORs are proposed by the project proponent as what would form the basis of their EI report. What are the terms or what are the criteria based on which the project proponent proposes to undertake the EI study? Along with that, a pre-feasibility report would also be submitted. All this information is then put forward or to the expert appraisal committee in case of category A projects, and in case of category B projects, it would be forwarded to the state expert appraisal committee. Now we have the 4 broad stages of the EI process. The first stage is called the screening stage. This stage is relevant only to category B projects. At this stage, the state expert appraisal committee looks through the documents that have been submitted by the project and decides whether this is a category B1 project or B2 projects. And this is based on the nature and location of the project and certain guidelines that the MOEF has given. The distinction between B1 and B2 projects is that B1 is considered to be higher in magnitude, higher in potential impacts, and B2 is considered to be relatively smaller. And because B2 projects are relatively smaller, these are not required to undertake an EIA study or an environmental impact assessment study. However, as you must remember, the stage of screening, which is the first stage in the process, is not relevant to category A projects. It is only for category B projects. The second stage of the process is what is known as the scoping. At this stage, the expert appraisal committee or the state expert appraisal committee in case of category B projects will consider all the documents that have been submitted by the project proponent. It may even consider undertaking a site visit, although that is optional, not mandatory. And based on these documents and its experience, because as I said earlier, these committees include experts, they will issue the final terms of reference. Now, as I mentioned earlier, the terms of reference are the basis on which the environmental impact assessment studies are carried out. So, therefore, they define the ambit of the impact assessment studies. So, the expert appraisal committees can propose their own terms of reference. They can customize or revise the terms of reference that have been submitted by the project proponents. If these TORs are not properly assessed, or if these TORs are not properly addressed in the EI report that the project proponent prepares, the EAC or the SEACs can even reject the proposed project proposal. Therefore, I just want to emphasize on the importance of the terms of reference in the whole process. The project proponents have to respond to every term of reference that is issued to it. At the scoping stage, which is stage 2 itself, the EAC or the SEAC can decide to reject the project itself. It can decide this based on the documents if it believes that the adverse impacts on the environment will not be mitigated by the project and are too high and irreversible in nature for the project to be carried out. So, at the second stage, the scoping stage itself, the project proposal can be rejected and the project proponent or the company has to be given reasons by the expert appraisal committees and the MOEF or the SEIAA why their project has been rejected. After the scoping is over and the terms of reference has been issued to the project proponent, the project proponent engages an external agency such as an environmental consultant to undertake an environmental impact assessment study for the proposed project. These studies could take varying lengths of time. They could, it could be a rapid environmental impact assessment, which means it's undertaken only over one season. It could be a comprehensive EI report, which means that the environmental impacts over the whole year or all seasons have been considered before preparing the report. Most project proponents prefer the rapid EIA because it's undertaken in a shorter period of time, although it could be said that it is not an adequate impact assessment because it doesn't take into account seasonal variability. Once these assessment studies are over, a draft EI report is prepared and along with a summary of 10 pages is submitted by the project proponent. Now we come to the third stage of the process, which is the public consultation, which I referred to briefly earlier. The public consultation has been defined as the process by which the concerns of local affected persons and others who have plausible stake in the environmental impacts of the project or activity are ascertained with a view to taking into account all material concerns in the project or activity design as appropriate. However, certain projects such as building and construction projects, townships, individual projects within big industrial estates, B2 category projects, certain expansion projects need not undertake public consultation. However, projects such as thermal power plants, mining projects, hydropower projects, nuclear, airports, massive industries, all these projects and development activities, infrastructure activities require public consultation. Public consultation under the EI process has two stages. The first is that of public hearing, where at the site of the project or close proximity to the site of the project, the State Pollution Control Board organizes a hearing. The second stage is where written responses or representations are sought from concerned persons who may have a plausible stake in the environmental aspects of the project. Now, these people who are involved in submitting written responses need not be people who are directly affected by the project or who live in close proximity to the project. They could be anyone who has any interest or plausible stake in the matter. Now, before the public hearing commences, there are several kind of procedural requirements. The first, the project proponent writes to the concerned State Pollution Control Board. So, for example, if the project is a mining activity being undertaken in the state of Odisha, then the Odisha State Pollution Control Board will be approached by the project proponent. The project proponent will submit the draft EI report along with the summary in English as well as in the local or official language of the state, for example, in Odia, in hard and soft copy to the concerned State Pollution Control Board. These documents also have to be submitted to the local administration offices such as that of the Gram Panchayat, the Zilla Parishad, the district industries offices. All local administration offices where the project is being undertaken would also be required to be served with the documents. Now, it's important that these documents are provided to these local offices because it is the only way through which affected communities and people can come to know details about the project and the potential impacts of these projects, so that they can raise concerns, ask questions, submit representations about the project based on the information provided to them. Before a public hearing is held, a notice has to be issued by the State Pollution Control Board at least 30 days in advance. And this notice has to be published in at least 2 newspapers, which is one could and both national language, a national daily and a regional daily. So it has to be one in English language and one in a regional language, giving information about where the public hearing is going to be held, and also the offices in which the documents are being kept for people to come and peruse if they are interested. The draft summary of the draft EI report has to be also made available on the Ministry of Environment and Forests website. Now, during the public hearing, there is no quorum requirement. Even if there are 2 people present at the public hearing can be continued. However, all those people who are attending the public hearing have to mark their attendance. A public hearing once scheduled cannot be postponed unless there are certain untoward kind of emergency situations. It is facilitated by the district magistrate or the district collector, and the project proponent is invited to present details about the project and what are the measures that are being undertaken by the project proponent to minimize their adverse impact assessment. The whole event is video recorded by the State Pollution Control Board, and any person in the audience who wishes to ask a question or seek any clarification or express his or her opinion has to be given an opportunity. No one can be denied an opportunity to speak at such a public hearing. Once the public hearing is over, the panel prepares the minutes of the meeting or the minutes of the public hearing, and then reads these minutes back to the people in the audience to verify that the minutes actually reflect what happened or what occurred during the hearing. The agreed minutes and the video that has been prepared by the State Pollution Control Board are then sent to the Ministry of Environment and Forest Climate Change in case of Category A projects, or to the SEIAA or the State Environment Impact Assessment Authority in case of Category B projects. Once the public hearing is over, the proceedings are displayed conspicuously outside the local offices, and of course, as I mentioned before, written representations may be sent by any person who is interested in the project, raising doubts, asking for clarification, or submitting additional information with regard to the project to the MOEF and the SEIAA. Once this is over, the project proponent is required to address the material environmental concerns raised during the public consultation and submit a final EI report, revising its earlier draft based on issues raised by the people during the public consultation. For example, if there is a project coming up on the coast, say in the state of Maharashtra, and people such as the fishermen are not satisfied with the kind of marine impact assessment that the project proponent has undertaken, the project proponent could undertake another additional study to see what the impact of its project is going to be on the marine biology and include this in the final EI report. Unfortunately, this final EI report is not made available to the people, and therefore they have no way of verifying whether their concerns have actually been addressed. Now we come to the last stage of the process, which is the appraisal stage, which is defined as detailed scrutiny by the Expert Appraisal Committee or the State Expert Appraisal Committee of the application and other documents like the final EI report, outcome of the public consultation including the public hearing proceedings submitted by the applicant to the regulatory authority concerned with the grant of environmental clearance. During this meeting of the EAC, when it is looking through all these documents, the EAC may invite the project proponent to come and explain certain aspects of the project or respond to certain questions or queries raised by committee members. They could also require project proponents to undertake additional studies. After all this process is over, the EAC or the SEAC make categorical recommendations to the Ministry of Environment and Forest Climate Change or to the SEIAA whether to grant clearance or to reject clearance to the said project. Generally, MOEFCC and the SEIA accept these recommendations, but there have been occasions when they have overruled these recommendations or have requested the expert appraisal bodies to reconsider their recommendation. If finally the MOEF decides to reject an environment clearance application, it has to give its reasons to the project proponent. However, if it accepts the environmental clearance application, a clearance letter is issued to the project proponent, which includes various conditions which the project proponent has to meet before it starts operations or even during construction and operation of the project. For example, it could be required to undertake catchment area treatment if it is coming up near a river. It could be required to undertake certain measures to protect groundwater from leaching. It could be required to undertake afforestation measures. So there could be several conditions that the project proponent is required to meet or comply with after it has received the environmental clearance. Once the environmental clearance letter is received by the project proponent, it has to make sure that this is advertised on its website. It is advertised in 2 national dailies in English language as well as regional language. That information about these clearances is available on the website of the MOEFCC or the SEIAA and the State Pollution Control Board. The concept behind this, of course, is to make sure that people know that the project has been granted clearance and what exactly are the conditions based on which the clearance has been granted, so that people can subsequently verify if the project proponent is actually meeting or complying with those conditions. The job or the onus of monitoring the compliance of these conditions lie with the Ministry of Environment and Forest and Climate Change with regard to Category A projects, and with regard to Category B projects, the onus lies on the State Environment Impact Assessment Authority. Now, coming to grievances within the system. Now, suppose the Environment Impact Assessment report include certain false information, or there is deliberate concealment of certain information with regard to the project site or the impact of the projects. An example could be that a project is coming up in a wetland, which is ecologically very important and fragile, and the EI report writes that this is not a wetland but a wasteland, which is an entirely different nature of land. Then this would constitute false representation or deliberate concealment of information. In this case, if it is found that the EI report is providing false information, the application for environment clearance can be rejected, and if the clearance has already been granted, then it can be subsequently cancelled. And if the project proponent has already undertaken certain kind of construction, it would be to the financial loss of the project proponent, who would then have to break down any form of operations which may, or construction which may have already begun. If work is commenced before any environment clearance is granted, then there could be an imprisonment penalty, or the company may be required to pay a fine, or the head of the company may be punished to go into jail for up to 5 or 7 years. Finally, if someone is not happy that an environment clearance is granted, he or she or an organization may file an appeal against such a decision before the National Green Tribunal. Similarly, a project proponent, if its clearance application has been rejected, can also file an appeal before the National Green Tribunal. Now we come towards the end of our discussion today, which are some of the main concerns with regard to this process. Of course, there are several concerns that have been raised by activists, civil society groups, local panchayats, as well as industries and government agencies who have raised problems with regard to the design and implementation, but I'll just highlight three such problems. First is that, as I mentioned, the EI report that is prepared is actually prepared by a consultant hired by the project proponent. Therefore, the credibility and accuracy of this project is extremely suspect, because there is a clear conflict of interest between the EI consultant and the project proponent. The EI consultant, since it is paid by the project proponent, is likely to give a very glorious account of what the project is proposing to do. Secondly, while the public consultation is a very important part of the whole process, there have been several cases where issues raised by the people during the public consultation are not reflected in the discussions before the appraisal committee, and nor are they reflected in the final EI report. As I mentioned earlier, the local people, the affected communities do not have access to this final EI report, and therefore they are actually not in a position to verify whether their concerns had actually been taken into account. And finally, a third concern that I'd like to highlight is that even if a clearance is granted to a project proponent, the monitoring mechanism in our government systems today is very poor. So all the conditions that the project is supposed to comply with, for example, if there are any corporate social responsibility related measures such as building a school or a primary health clinic or roads, or to ensure that there is a green belt, all these conditions which are included in the environmental clearance, which the project proponent has to comply with, he may not comply with, and that is not properly monitored, and they are not held accountable for these kind of violations. To summarize today's discussion, we started the discussion by looking at why project proponents and industries require environmental clearances. We looked at the relevant law, which is the Environmental Protection Act of 1986 and the EI notification 2006 that has been issued by the central government under it. We discussed the main institutions at the central, state government and the local administration. We looked at the 4 stages of the process: screening, scoping, public consultation and appraisal, ending with the final decision whether to grant clearance or not, as well as the post-clearance monitoring mechanism. We discussed some of the grievances that may arise, such as violations of the law, what could be the penalty provisions, and we ended by discussing the major concerns that have been highlighted over the last 8 years of this EI notification 2006 and the environmental clearance process being enforced. I thank you all for being part of this discussion. I hope you enjoyed it. Thank you very much.